It took just 3 days for Trump to lose his first lawsuit during his second term as president. This one's the Birthright Citizenship Executive Order. He purported to take away birthright citizenship by executive order. Of course, it's enshrined in the 14th Amendment to the United States Constitution. So, of course, Trump can't modify the Constitution by executive order. It requires ratification by the Congress and the states, 2/3 majority in Congress and 3/4 of the several states. Let's take a look at how he lost this and how he lost it so quickly. This is in the United States District Court for the Western District of Washington, and this is the states of Washington, Arizona, Illinois, and Oregon against Trump and everybody. This is a motion for a temporary restraining order. What does that mean? Does it mean that the result is temporary? Yes, but it also means that the judge will follow up, and the judge will issue a preliminary injunction during the litigation, and then eventually a permanent injunction at the conclusion of the trial or summary judgment, or even motion for judgment on the pleadings, since this is so outside of the president's jurisdiction. The Citizenship Clause of the 14th Amendment emerged out of one of our nation's darkest chapters and embodied one of its most solemn promises. It was passed and ratified following the Civil War to overturn the Supreme Court's infamous holding in Dred Scott v. Sanford in 1857, which denied citizenship to an entire class of persons, descendants of enslaved people. The Citizenship Clause repudiated Dred Scott and reaffirmed the long-standing common law principle of jus soli. All individuals born in the United States and subject to its jurisdiction are citizens. Its operation is automatic and its scope broad. It provides our nation a bright line and nearly universal rule under which citizenship cannot be conditioned on one's race, ethnicity, alienage, or the immigration status of one's parents. The President's Executive Order of January 20th, 2025, the Citizenship Stripping Order, declares that children born to parents who are undocumented or who have lawful but temporary status lack citizenship and directs federal agencies to deprive those individuals of their rights. As a result of the Citizenship Stripping Order, the plaintiff states will suffer direct losses of federal funds that are conditioned on their resident citizenship and will incur immediate, substantial, and unbudgeted expenditures to implement the massive changes required to state programs and systems, none of which the plaintiff states can recoup through this case or otherwise. The plaintiff states will also suffer irreparable harm because thousands of children will be born within their borders but denied full participation and opportunity in American society. Absent a temporary restraining order, children born in the plaintiff states will soon be rendered undocumented, subject to removal or detention, and many stateless. They will be denied their right to travel freely and re-enter the United States. They will lose their ability to obtain a Social Security number and work lawfully. They will be denied their right to vote, serve on juries, and run for certain offices, and they will be placed into positions of instability and insecurity as part of the new, presidentially created underclass in the United States. The Citizenship Stripping Order declares that U.S. citizenship does not automatically extend to persons born in the U.S. if the individual's mother is unlawfully present in the U.S. and the father was not a citizen or lawful permanent resident at the time of the person's birth, or to the person's mother's presence in the United States at the time of said person's birth was lawful but temporary, and the father was not a citizen or otherwise a lawful permanent resident at the time of birth. The order states that it is the policy of the United States that no department or agency of the federal government shall issue documents recognizing such persons as U.S. citizens, nor accept documents issued by state governments recognizing the same. The order directs agencies to take the appropriate measures to ensure that the regulations and policies of their respective departments and agencies are consistent with this order. The consequences of this order will be severe and long-lasting. Undocumented students are less likely to complete high school or enroll in higher education and will earn less at almost every stage of their lifetimes than their citizen counterparts. They will be more likely than their citizen peers to experience disease, depression, anxiety, and social isolation. They will be ineligible for food and cash assistance, critical benefits to prevent childhood poverty and ensure access to nutrition. Stated differently, denying birthright citizenship to children born in the U.S. to undocumented parents will create a permanent underclass of people who are excluded from U.S. citizenship and are thus not able to realize their full potential. birthright citizenship is a cornerstone of the U.S. identity as a nation of immigrants, promoting social cohesion, opportunity, and mobility. Ending birthright citizenship would erode these principles and divide our national community, creating and reinforcing vast inequality for generations to come. The citizenship stripping order will also directly injure the plaintiff states by reducing their federal funding and reimbursements through programs that states administer, such as Medicaid, the Children's Health Insurance Program, the Title IV foster care and adoption assistance programs, and programs to facilitate streamlined issuance of Social Security numbers to eligible babies, among others. So the plaintiff states have made a motion for a temporary restraining order. This gives the court the ability to issue a 14-day order restricting the thing they're asking for if the judge agrees that certain elements are present, like a likelihood of success on the merits. So this is a kind of a pre-win. You have to show that you're likely to win the case before you even get started. So here they were able to show that they are likely to win the case in just 2 days. In fact, it was basically just 1 day. They filed this lawsuit and this motion 1 day after the executive order denying birthright citizenship. And then the judge was able to rule on that within 2 more days. So the temporary restraining order was written, filed, and ruled on within 3 days. That's the expediency of the federal courts when they want to and when they have good cause. So, the arguments in favor of the likelihood of success on the merits. The plaintiff states will succeed on the merits because the citizenship stripping order unlawfully attempts to rob individuals born in the U.S. of their constitutionally conferred citizenship. A wall of Supreme Court, Ninth Circuit, and executive branch authority all make clear that children born in the United States in the coming weeks are citizens just like all children born in the U.S. for more than 150 years. The citizenship stripping order is unlawful because its limited view of birthright citizenship is contrary to the 14th Amendment's text and history, century-old Supreme Court precedent, and long-standing executive branch interpretation, as well as the Immigration and Nationality Act. Section 1 of the 14th Amendment of the Constitution states, quote, "All persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." This provision is known as the Citizenship Clause, and it contains no exceptions for children born to non-citizens or undocumented immigrants. Likewise, the Immigration and Nationality Act faithfully tracks the Citizenship Clause's language stating, "The following shall be nationals and citizens of the United States at birth, a person born in the United States and subject to the jurisdiction thereof." Any violations of the Citizenship Clause likewise violate the INA because Congress adopted identical language. The only individuals excluded are those who are not, in fact, subject to the jurisdiction of the United States at birth. The children of diplomats covered by diplomatic immunity and children born to foreign armies at war against the United States while on United States soil. No exception is provided when children are born in the United States to undocumented parents. They must comply with U.S. law, so too must their parents. Undocumented immigrants pay taxes, must register for the Selective Service, and must otherwise follow and are protected by the law, just like anyone else, within the United States territorial sweep. The history of the Citizenship Clause confirms this long-standing, recognized meaning of its plain language. Birthright citizenship stems from English common law's principle of jus soli, citizenship determined by birthplace. The American colonies accepted and relied on that common law principle until Dred Scott denied citizenship to descendants of enslaved individuals in 1857. In response to Dred Scott and the Civil War, Congress and the states adopted the 14th Amendment to once again make clear that birthright citizenship is enshrined in the United States with only narrow exceptions for the limited group of individuals who are truly not subject to United States law. The Supreme Court has made clear that undocumented immigrants are subject to the jurisdiction of the United States. In Plyler v. Doe, a 1982 Supreme Court case, the court interpreted the 14th Amendment's Equal Protection Clause, the sentence immediately following the Citizenship Clause, and explained that the term within its jurisdiction makes plain that the 14th Amendment extends to anyone, citizen or stranger, who is subject to the laws of a state and reaches into every corner of a state's territory. During World War II, the Ninth Circuit affirmed a district court's rejection of an attempt to strike from the voter rolls 2,600 people of Japanese descent who were born in the United States in Reagan v. King. Reagan v. King was appealed to the Supreme Court, who denied to overturn it, denied certiorari, denied to even hear it, in 1943. In that case, it was deemed, quote, unnecessary to discuss the arguments of counsel that challenged those individuals' citizenship because it was settled that a child born within the United States is a U.S. citizen. The executive branch, too, has long endorsed this understanding of the citizenship clause. When the U.S. Department of Justice's Office of Legal Counsel was asked in 1995 to assess the constitutionality of a bill that would deny citizenship to children unless a parent was a citizen or permanent resident alien, the OLC reasoned that this legislation is unquestionably unconstitutional. One of the other elements is the fairness and public interest. I'm simplifying here for the purposes of a digestible video, but this is the fairness and public interest argument from the plaintiffs. With the citizenship stripping order, the president attempts to return our nation to a reprehensible chapter of American history when Dred Scott excluded Black Americans from citizenship, a view of citizenship soundly rejected by the people and their representatives in the 14th Amendment. This court should not allow a return to a regime where Americans born on U.S. soil are excluded from our citizenry at the whims of politicians. This grave deprivation of constitutional rights belies any public interest in the order because public interest concerns are implicated when a constitutional right has been violated. All citizens have a stake in upholding the Constitution. In addition to denying the rights of citizenship, the vast majority of those subject to the order will be condemned to the additional harm of living with undocumented legal status. Most of the babies denied citizenship will be left with no legal immigration status and no prospects for legalization, absent change in U.S. immigration laws. Children left without legal status will lose protection from deportation and will be placed at risk of family separation or being forcibly sent to a country they have never stepped foot in. Statelessness, as the Supreme Court put it, would assign these children a fate of ever-increasing fear and distress. One such harm is the deprivation of one's fundamental right to travel. Travel abroad, like travel within the country, may be as close to the heart of the individual as the choice of what he eats or wears or reads. Freedom of movement is basic in our scheme of values. The order deprives those subject to it of the right to travel by denying eligibility to obtain a passport and bars them from re-entry to the United States. Depriving children born and residing in the plaintiff states of citizenship will further harm their economic, educational, and mental health outcomes, depriving states of the human capital and economic contribution that results from the full social and economic integration of youth into society. In sum, the federal government has no legitimate public interest in enforcing the unconstitutional order. The only justification offered for the citizenship stripping order is that it may deter unlawful immigration, a hypothetical rationale and political motivation that can never overcome an unlawful deprivation of constitutional rights. Indeed, the entire point of the citizenship clause was to remove the weaponization of citizenship status as a policy tool. The government has lawful means to control and affect immigration policy without violating the 14th Amendment. This order is not one of them, and it should be enjoined before it ever takes effect. And that is written by Nicholas Brown, Attorney General, and Lane Polizzola from Colleen Melody, Daniel Gian, Allison Gnam. Very well written. And there are others here. I don't mean to overlook them. Thank you all for all of your hard work on that. For their part, the Justice Department's attorneys did actually respond, pretty much doubling down that those people who are born in the United States and subject to its jurisdiction excludes children of non-citizens here illegally. Now, you'll see that I don't have any room for that in my brain, and neither does the judge, because, of course, even illegal immigrants are still subject to the jurisdiction of the United States and can be caught and deported, locked up for any crimes they've committed, etc. They are subject to the jurisdiction of the United States. Do you know who is not subject to the jurisdiction of the United States? Is people who we say are not subject to the jurisdiction of the United States, which is people with diplomatic immunity who are immune from the jurisdiction of the United States when they are here diplomatically, and soldiers who fight in wars against the United States on U.S. soil, which has not happened yet. So we don't have that one as a precedent. But for their part, the Department of Justice lawyers claim that people who are here in the U.S. illegally are not subject to its jurisdiction, which is false. That's just plainly false. Then they attack on standing grounds, basically that the plaintiffs don't suffer any injuries whatsoever, therefore they can't bring a case because you need to have suffered an injury. The judge also had no room for it. I've been on the bench for over 4 decades. I can't remember another case where the question presented is as clear as this one. This is a blatantly unconstitutional order, said Judge Coffenor, an appointee of Ronald Reagan. There are other times in world history where we look back and people of goodwill can say, where were the judges? Where were the lawyers? Coffenor interrupted before Brett Shumate, a Justice Department attorney, could even complete his first sentence. In your opinion, is this executive order constitutional? He asked. Shumate said, it absolutely is. Frankly, I have difficulty understanding how a member of the bar could state unequivocally that this is a constitutional order. It just boggles my mind. Now let's see what the judge has to say in granting the temporary restraining order. This matter comes before the court on the emergency motion for a temporary restraining order filed by Washington, Arizona, Illinois, and Oregon. The court grants the plaintiff's emergency motion for a 14-day temporary restraining order. The court enters the following findings of fact. Plaintiff states face irreparable injury as a result of the signing and implementation of the executive order. The order harms the plaintiff states directly by forcing state agencies to lose federal funding and incur substantial costs to provide essential and legally required medical care and social services to resident children subject to the order. Plaintiff states' residents are also irreparably harmed by depriving them of their constitutional right to citizenship and all the associated rights and benefits, including subjecting them to risk of deportation and family separation, depriving them of access to federal funding for medical care and eligibility for basic public benefits that prevent child poverty and promote child health, and impacting their education, employment, and health. These harms are immediate, ongoing, and significant, and cannot be remedied in the ordinary course of litigation. A temporary restraining order against defendants as provided below is necessary until the court can consider plaintiff state's forthcoming motion for a preliminary injunction. To obtain a temporary restraining order, they must establish a likelihood of success on the merits, irreparable harm, and equities and public interest tip in their favor. There is a strong likelihood that plaintiffs will succeed on the merits of their claims that the executive order violates the 14th Amendment and Immigration and Nationality Act. The plaintiff states have also shown that they are likely to suffer irreparable harm in the absence of preliminary relief. The executive order will directly impact plaintiff states, immediately increasing unrecoverable costs for providing essential medical care and social services to states' residents, and creating substantial administrative burdens for state agencies that are forced to comply with the order. Moreover, the states will suffer immediate repercussions of the order's mandates as described in its enforcement section. The balance of equities tips towards the plaintiff states and public interest strongly weighs in favor of entering temporary relief. Defendants are thereby ordered, they are fully enjoined from enforcing or implementing Section 2A, 3A, and 3B of the executive order, and the injunction remains in effect pending further orders from the court. So 2A is the denial of birthright citizenship, 3A will be take all measures, and 3B shall issue public guidance. It basically eliminates the entire meaningful part of the order, and the rest is just definitions and statements. So yeah, Trump already lost his first lawsuit in the first 3 days. Now, yes, I can hear what he's saying out there. No, he hasn't lost the lawsuit yet. It's just a temporary restraining order. You're right. You're right in the technical sense. But not even this Supreme Court, made up of a majority of conservatives, and including Clarence Thomas and others who are going to try and use textualism or originalism, not even those arguments overcome the inability of a executive branch officer, the President of the United States, to overcome constitutional amendments. It's the highest power in the land. The constitutional amendment is the highest power in the land. The Constitution is how everything gets its power. A constitutional amendment is the Constitution. It is added on later as an amendment, but it has the same power as the Constitution. The Bill of Rights is the same as the Constitution, even though they are 10 amendments to the Constitution that were passed rather rapidly after the text of the base Constitution, the unamended Constitution. So there is no way that an executive order would ever overcome a constitutional amendment. What they attempted to do was redefine the meaning of subject to the jurisdiction thereof, which, again, cannot be redefined by executive order like that. It is in the Constitution, and the meaning of the text of the original Constitution is going to, shall I say, trump any order that the president could make. So I don't think we're in terrible danger of birthright citizenship being actually overturned. I give it a less than 3% chance. But the subterfuge, the stochastic terrorism, the fear, uncertainty, and doubt caused by a flood of things changing and everyone having to jump to respond to it in time. The cruelty is the point, not because we actually think that there was a good case here to win an overturning of birthright citizenship without a constitutional amendment. Thank you for watching. Don't forget to like and subscribe, and let me know what you think in the comments below.